Hello, this is Sally Annero from Taylor Wessing, and welcome to our webinar today. This is part of our ongoing webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees are going to be very familiar with our previous topics, which have included subjects such as managing cybersecurity risks, data transfers and privacy shield, use of CCTV systems, data protection and employment, and of course the EU data protection regulation, among many other subjects. And recordings of those webinars and others are still available from our Global Data Hub microsite if you missed them and you still would like to engage with those topics. Today we're going to be looking at media content and data protection. For those of you who are new to Taylor Wessing or new to our webinar program, hello and welcome. As you'll see from the slide, Taylor Wessing is an international law firm. We act for a range of leading clients in local and international markets, where we provide a full-service law firm offering from an office footprint that spans across Northern, Central, and Eastern Europe, the Middle East, and Asia. And we've listed some details about the firm on the slide deck for you. Today's webinar is brought to you by Taylor Wessing's data protection practice, and we advise on all the full range of both data protection and information law issues from our office footprint. Our international data protection practice is a global 22 partner-driven team, and we're also complemented by an international network of data privacy law specialists. At Taylor Wessing, we have a dedicated microsite, the Global Data Hub, that's specifically for all things data protection. And from this site, you'll be able to access news and weekly updates and a bi-monthly mail shot if you register. There are also topical issues where we take a regular look at subjects that are raising concerns, issues or challenges from an information law perspective. And we provide details of our forthcoming webinars, and you can also access the recordings of our archived webinars, as I mentioned earlier. As I mentioned, my name is Sally Annero, and I'm a senior member of the London Data Protection Practice. I'm also joined today by my colleague Tim Pinto, who is Senior Counsel in Taylor Wessing's IP and Media Practice, and you'll see that both of our profile details are on this slide for your information. So, in today's webinar, we're going to be focusing on data protection and media content, including its relationship with defamation and with individuals' wider privacy rights. We'll also look at the relevance of data protection law and the scope of the available data protection law exemptions. However, before we turn to our main topic of the day, I'm just going to touch first on the elephant in the room, as it were. That's the recent referendum result and what this means generally for data protection law in the UK. In the aftermath of the referendum result, the impact of Brexit, the form it will take and when exactly it will happen are all being pretty hotly debated. We're clearly now navigating in quite uncharted waters, but that doesn't mean we can't perhaps anticipate what this might mean and prepare for the potential challenges or opportunities that present themselves. Among the many questions is how data protection law will be affected by the leave vote. We currently have the Data Protection Act 1990 in force, and at present that law continues to apply. The issue we have to confront is when the new data protection law in the form of the General Data Protection Regulation comes fully into effect in May of 2018. At that point, we're likely still to be in the EU, given that it remains unclear when Brexit mechanism and Article 50 of the Lisbon Treaty will be triggered, and the Brexit negotiations are therefore still likely to be ongoing. In addition, we've got no foresight at this time as to the form that any eventual exit from Europe or our future relationship with Europe will take. So this uncertainty may lead some to query whether they can carry on with, or whether they should carry on with upscaling their data protection compliance to meet the requirements of the General Data Protection Regulation, or whether this is an opportunity for the UK to, in fact, be reviewing its lawmaking in this area and to instead introduce a lighter touch regime. For reasons I'll explain, however, the practical realities of this are quite different. To explain, we should bear in mind that a vast number of the EU businesses, UK businesses, are trading internationally, and this will include with the EU. Where these businesses also have feet on the ground in the EU, perhaps by way of group companies and subsidiaries, this will mean that the GDPR will apply to those entities. Alternatively, where that's not the case, but those UK businesses are offering goods or services into the EU, or they're monitoring EU subjects, then the extraterritorial reach of the GDPR is going to mean that those trading businesses will in any event be directly subject to the requirements of the GDPR, even if they're not in Europe. Even where either of those scenarios don't apply, it's clear that the effect of the GDPR will not be possible to ignore. The ICO, the regulator of the UK Data Protection Act, said in a statement soon after the referendum results became known that if the UK wished to trade with the EU on equal terms and receive data flows from the EU into the UK, then we would need to ensure the adequacy of our data protection laws in order to satisfy those data transfer restrictions built into EU law, both now and in the future under the GDPR. The current UK Data Protection Act will not provide an equivalent standard of protection for processing personal data as set by the GDPR. So this means that our UK data protection law must either be the same as the GDPR, implement the GDPR, or be of an equivalent standard to the GDPR at the point the GDPR entered into force. If we negotiated an exit where we remain within the EEA, then we would need to adopt the terms of the GDPR into our national law. If our exit's more comprehensive, though, then the EC might find itself having to consider if the UK provided for a data protection regime that's adequate, and an EC adequacy decision would be needed to enable that free flow of personal data from the EU to the UK. This decision would mean having to consider how robust the UK's data protection laws were. We only have to consider the quite intense scrutiny of the recently approved US Privacy Shield replacement for the safe harbour mechanism to understand the approach that the Commission may take if it has to make an adequacy assessment for the UK's post-Brexit data protection regime. One key issue in the invalidation of the safe harbour scheme by the Court of Justice of the European Union for exports to US certified recipients was the lack of any proportionality or necessity for access to the personal data of EU citizens by the US intelligence agencies, and the lack of redress that those citizens had in relation to that. The Working Party of EU regulators commented at the time that the replacement for the Privacy Shield was being worked up that adequacy with EU law wasn't just an issue for the US, but it's also an issue for other countries. And in this respect, the UK has previously been criticised for its weak adoption of data protection law. And as well, there's also been concerns raised generally around surveillance and the provision through the Investigatory Powers Bill, for example, of bulk interception of citizens' communications. So just using those examples, clearly any adequacy consideration of UK data protection law could ultimately prove to be equally as problematic as that the US has gone through. For all these reasons, the UK is therefore inevitably going to need to have to adopt robust protections for personal data to make sure that its data protection law isn't going to be a barrier to trade and to commerce, whether that's by adopting the GDPR into our national law or whether it's by upscaling the current Data Protection Act 1998 to set a standard of protection that's in effect equivalent to that's set by the GDPR. So having dispensed with that elephant in the room, and having set the scene as to perhaps why data protection law and compliance with upgraded standards will remain important, we're now going to turn back to our main topic of the day, data protection media content. And with that, I'll hand over to my colleague, Tim Pinto.
Thank you, Sally. Hello, everybody. The main topic is today the use of data protection law in relation to media content, such as newspaper articles or broadcasts. And normally, if a person has an issue with media content, they rely on defamation law or privacy law or privacy law. Defamation law is to protect somebody's reputation, and privacy law is about private information. But data protection law can also apply in this context too, and that is the main topic of today. I'm first going to give an overview of defamation and privacy law in England, just to set the scene, and then after that, Sally and I will explain how data protection law can be used instead of or in addition to standard defamation and privacy law. And we have attendees on this webinar from media companies and non-media companies. For media companies, the webinar is relevant on how, why is data protection law relevant and how to deal with claims. For non-media companies, the webinar is relevant in how would an individual deploy data protection law in relation to media content. And for everybody, it just shows how wide and important data protection law has become. So the first topic is defamation, and this is about disparaging statements. And the first thing that a claimant has to show is that the words complained of, whether it's written words or in a broadcast or on the radio, are defamatory. And under English law, that means, there's a legal definition for it. It's a statement that substantially affects, in an adverse manner, the attitude of other people towards the claimant. In other words, the statement is disparaging the claimant. But under English law, there's an additional test that has to be established by a claimant. The claimant has to prove that the statement has caused or is likely to cause for an individual serious harm to their reputation. And they have to prove this with evidence. So there's a real hurdle there that claimants have to get over when they want to rely on defamation law. In fact, there's two hurdles, the two bullet points in the slide. For a body trading for profit, and this is companies, they have to prove serious financial loss. But since this is a talk about data protection law, we're not going to talk about companies here because data protection law relates to individuals. So, what are the defences to a defamation claim? If the claimant can prove that the words are defamatory, well, the defences are truth, honest opinion, and there's a public interest defence as well. And under English law, if it's a statement on a matter of public interest, the defendant, that might be a publisher, a media company, a journalist, or even anybody else for that matter, having to defend a defamation claim, they have to prove that they reasonably believed publication was in the public interest. And in England, the defendant has the burden of proof. In fact, the laws in other countries are quite different. So, for example, in the United States, law is much more in favour of free speech, and it's much more difficult to bring a defamation claim, especially against the media defendant. So that's a quick overview of defamation law in England. Privacy law, this is all about private information, and it doesn't matter if the information is true or false, it has to be private. So someone who wants to complain about information under the law of privacy, the first hurdle is the information private, and the test is whether the person has a reasonable expectation of privacy. And obviously private information in general is about someone's sex life or their health condition or their private finances, their tax and things like that. But of course there's freedom of expression as well, which is very important. So even if they prove that the information is private, the courts carry out a balancing exercise, and they balance the right to free speech, the right of the public to know the information, against the right of the individual to keep the information private. and there's a proportionality exercise that goes on as to which interests come out on top. But the most important thing for privacy law is the information must be private, and we'll come to the difference of data protection law in a minute. Just to give you one illustration of a privacy and data protection claim in the English court, there's an English pop star called Paul Weller, and he was in Santa Monica in California with his children, his daughter Dylan. They've all got musical names, who was 16 at the time, and then twins, John Paul and Bowie, who were 11 months old at the time, and Associated newspapers published some photographs of them walking down the street in Santa Monica with their father under the headline "A Family Day Off," and the English court held that was an infringement of privacy and data protection because there was no public interest in publishing what the court said were private photographs of a family day out. And some damages were awarded to the children, which you can see on the slide. US law would have given a different result on this because things in a public place under US law are not private, unlike this case in England. So that's a quick run-through of defamation and privacy. The key point here is you've got to prove that something's defamatory to bring a defamation claim, and you've got to prove that something's private to bring a privacy claim. So the next thing we'll do, and Sally will start this, is to explain the basic principles of data protection law, and then you can see how they would fit in a media context.
Thanks, Tim. Before understanding, as Tim said, the scope of the particular application of UK data protection law to media content, it's worth just a quick reminder of the general extent of data protection law to start to understand how the wide scope of these requirements to personal data processing in connection with the media could on their face give rise to points of tension. We know that data protection law applies to any organisation that handles information about living individuals, including the media. This information may be about any individuals, could be employees, customers, subscribers, authors, people about whom information is published as well. The law also recognises that certain categories of data processed about individuals can be sensitive, including health, race, sex, life, religious beliefs, opinions, trade union membership, and criminal activity, allegations or proceedings. And in those cases, additional requirements may also apply. All of these categories of data could potentially be found within certain published content. The data protection law governs the processing of this data. It's the personal data of these individuals who are described as data subjects. And this data may be in electronic form, such as electronic notes from a journalist or drafts, but could also exist across a host of other forms, including image information, such as the photographs that Tim mentioned in the Weller case. It could be audio files, such as interviews with individuals, or information held in organised paper files, including structured notes. And of course, processing is a very wide term applying to any use of this personal data from the very first point it's collected and recorded, including its retention, disclosure, and through to its destruction and eventual disposal. In other words, it applies to potentially any activity involving personal data across the full life cycle of that information. Any organisation that decides why or how personal data are processed will be a data controller, and a media organisation that is publishing content would be a data controller in relation to any personal data it processes for that reason. Whereas those that only process personal data under instructions are the data processors. So it's the data controller who under the current law carries the full compliance responsibility, including notifying the UK regulator, the ICO, about their processing of personal data and complying with the data protection principles. And as data controllers, media organisations will be responsible for the personal information they process. Controllers are also responsible for the personal data processed on their behalf by data processors and must carry out appropriate diligence when selecting processors and flow down contractual obligations around the processing of that data to ensure that it's only processed under instructions and that it's kept secure. At the heart of the data protection law are the 8 data protection principles I mentioned, which apply to all processing of personal data unless an exemption applies. But the principles don't set out black and white requirements. Rather, they provide broad enforceable standards that have to be interpreted on a case-by-case basis for particular processing operations, and this is particularly relevant in the context of media content and its the processing of the data with a view to the publication of that content. In the case of the first principle, this is quite a key principle here because there's a need to establish a legitimate basis for processing to ensure collection is fair and lawful and doesn't cause unjustified harm or intrusion into someone's private life. Separate conditions are also relevant where processing sensitive personal data, which includes where the subject perhaps has explicitly consented to the processing of the information, or where the information has already been made public, perhaps because of steps that the subject has deliberately taken, which has put that information into the public domain. Transparency and processing for specified purposes are also required outcomes from compliance with the principles, meaning that it has to be clear to people why their personal data is being collected and how it will be used, and that the data is not used in other ways, which on its face doesn't sit comfortably with, in the context of media content, with, for example, researching or investigating journalistic material pre-publication. The principles also focus on accuracy, so where information is recorded, the need for information to be recorded correctly, and that for reasonable steps to be taken to check the facts and to distinguish clearly between fact and opinion, because opinion is also personal data under the Act. The principles also focus on retention, ensuring that retained information is kept under review and that it remains up to date, relevant and not excessive, and that it's deleted where it's no longer needed. And in the media context, quite clearly, publishing organisations might be collecting and retaining and cross-referencing quite large stores of records that perhaps may not have an immediate relevance, but may be relevant for an article further down the line. And that's quite common practice. And of course, there are other requirements that data is kept secure and not sent to anyone outside of the EEA, notwithstanding that publication of media content, including personal data these days, is likely to be online and distributed to a global audience. And of course, data controllers must also comply with the rights that people have in respect to their data. And to consider that further, I'll pass back to Tim to remind us of what those key rights here are.
So in relation to media content, an individual might look at the following 3 rights in particular. They would look at their right, their subject access right under Section 7 of the UK Act, which is the right to receive information from a media company, and that sits very uncomfortably with journalistic activities, as you can imagine. They also could rely on their right under Section 10 of the UK Act, where the data subject can require the data controller to cease processing on the ground that the processing is likely to cause unwarranted substantial damage or distress. And under another section, they can ask the court to order the data controller, this would be the media company, to rectify, block, erase or destroy inaccurate data. So if you look at this in comparison with defamation and privacy law, if somebody used data protection law, they would not have to show the words are defamatory, and they would not have to show that the words are private. So data protection law potentially is actually easier for someone to make a claim with than defamation law or privacy law, because that first hurdle, the defamatory hurdle or the private hurdle, isn't there. So on the face of it, data protection law potentially looks stronger for a claimant than traditional media law. But of course, that's not the end of the story, and this has to be balanced with the rights of freedom of expression, which are also crucial and a significant part of data protection law. And that's the key part of this talk that we're going to turn to now. So there is a journalistic exemption, and if there wasn't, the media would have real difficulties publishing anything that people didn't like. So what is the exemption? Well, the media, in fact non-media who do journalistic activities, have to show 4 things, and if they can, there's an exemption from the main data protection principles. So, the first thing they have to show is processing the personal data, that's information about a person, only for the purposes of, in this example, journalism. There's also an exception for art and literature, but they're only processing for the purposes of journalism. They're processing with a view to publication of any journalistic material, and this is the key part of the test, the data controller reasonably believes that having regard to the special importance of the public interest in freedom of expression, that publication would be in the public interest, and compliance with data protection law would be incompatible with, in this case, journalism. So let's just recap on the key test. The data controller reasonably believes publication would be in the public interest. And if they can show that, then they wouldn't have to respond and give away information on the subject access request. And there's also an exemption from Section 10, the right to require a data controller to cease processing, and Section 14 as well, the right to order someone to rectify, block or erase data. So what is in the public interest? Now, of course, it's easy to ask that question and very difficult to answer it, but under UK law, for example, the public interest has been explained to an extent by our Information Commissioner's Office, and they've given examples such as content about crime, corruption and injustice, antisocial conduct, incompetence, negligence, preventing people being misled, protecting health and safety, and assisting the public in a better understanding of decisions of public importance. So public interest is quite a high-level concept here. My understanding is under American law, public interest is generally what's interesting to the public, whereas under UK law, public interest is sort of more to do with the functioning of democracy and preventing crime and injustice. The Information Commissioner's Office has given some factors which you take into account when deciding whether something's in the public interest, which are on the right-hand side of that slide. For example, the level of intrusion, the potential harm, the role and profile of an individual. So, for example, a politician would expect much more scrutiny and has much less protection than a private individual. And there has been one decision relating to what is in the public interest and the journalistic exemption. This is a decision of the UK Information Commissioner's Office in a case which was litigation between several individuals and Global Witness, which is a campaign organisation against corruption. The decision of the ICO was in 2014. Global Witness was investigating allegations that a company had secured a major mining deal in Guinea through corruption. The claimant denied the allegation and sued, including under data protection law, and they made a subject access request, amongst other things, to try and get information from Global Witness. And Global Witness relied on the journalistic exemption, and the Information Commissioner's Office held, in this case, that the journalistic exemption would apply because the processing was only for reporting the particular controversy, and Global Witness aimed to publish reports and the personal data which they were processing was connected to those publications. The fact that they didn't intend to publish the personal data itself wasn't a relevant consideration. And then on the test of whether Global Witness had a reasonable belief that what they were publishing would be in the public interest, the ICO said it's not the role of the ICO to decide if there's a public interest. The question is whether Global Witness's belief was reasonable. And they said that it was, given the high value of the mining deal in Guinea, in one of the poorest countries in the world. And finally, and importantly, they said that compliance with a subject access request was incompatible with freedom of speech and journalism, as if somebody could get hold of the personal data using a subject access request against the media, this would give away a future story and also undermine journalist sources who may not come forward in the future. So the journalistic exemption applied in this case. I have to say it's a fairly obvious case for the journalistic exemption to apply. I'm sure there's going to be in the future more borderline cases. This case also shows that it's not necessarily a classic media company that the journalistic exemption can apply to. Global Witness is a campaign organisation and not a classic traditional mainstream media company. So if an article or a news piece or a broadcast is in the public interest, this is very good for the media because the journalistic exemption is pretty strong. But if there is no public interest, then the data subject and data protection law provides very, very powerful rights. So if the journalistic exemption doesn't apply, then the data subject has quite a few things they can deploy under data protection law, and sort of a pure, fairly intrusive celebrity story, for example, with no public interest under the definition in UK law, could be more difficult for the media to justify, whereas it wouldn't really make much difference with a more public interest story such as the Global Witness one in the future. The ICO, if anyone's interested, the ICO has written a booklet on data protection and journalism, a guide for the media, and in there it recommends that media companies give all staff basic data protection awareness training, and they have clear policies on what needs editorial approval. They have inbuilt public interest. This is what the Information Commissioner recommends: inbuilt public interest checks at key stages in producing an article, and that the media should keep an audit trail for unusually high-profile or intrusive stories. So this is the kind of new level of obligation for the media. So in summary, just to recap, data protection law is now firmly part of media law, at least in the UK. And now we want to deal with another aspect, which is a similar aspect, which is called the right to be forgotten. And I'm sure many of the people on this call, if not all of them, have heard of this. This is where an individual can try to remove links from a search engine about them. Search engines can present a profile of a person and be very powerful in describing people as a result of searches. And in this case, the Gonzalez against Google Spain case, 2014, Mr. Gonzalez asked Google to remove certain information and a link relating to a 1998 Spanish newspaper article, and Mr. Gonzalez said the reference was now irrelevant. Mr. Gonzalez's wish to be forgotten obviously didn't quite succeed because lawyers have been talking about it ever since. And Google resisted the application on several grounds, but interestingly, they didn't rely on the journalistic exemption because, as a search engine, they see themselves as a platform rather than doing journalism. So the Court of Justice of the European Union held the following 4 points. In general, the data subject's rights override the interests of the search engine and of internet users, and that's fairly radical if you think about the balance between free speech and the protection of reputation and privacy. And this is data protection law rather than traditional media law. The balance depends on, for example, the role played by the data subject in public life. There might be a politician and the public interest in having access to the information. And if conditions are met for erasure, the search engine must erase links even if the original article remains online or is lawful. The one thing I would say in caution on the right to be forgotten is, of course, if somebody tries to remove information from a search engine, that could actually cause a news story in itself. So it may backfire. So it's a two-edged sword. But it's another example of data protection law being used in relation to immediate context, and it just shows how wide data protection law is. So the next part of the talk, Sally's going to update us on the future of data protection law, and I'll hand over to her now.
Thanks, Tim. In particular, the Google Spain case that Tim mentioned anticipated a change that was being reflected in the revision of the European data protection law by way of a right to be forgotten that was included in the proposals for the General Data Protection Regulation. And this right survives through to the final text, although it's now referred to as the right to erasure. This differs, however, from the erasure right that we're familiar with under the current Data Protection Act in the UK, where erasure is only a right where the processing is causing unwarranted or substantial damage or distress. This threshold isn't found in the right under the General Data Protection Regulation, although in cases where there is damage or distress, then the argument, for example, that there is no legitimate interest in the continued processing is going to be stronger. This right doesn't provide an absolute right to be forgotten. Rather, it's a right under certain circumstances for individuals to have their personal data, including where the data is no longer necessary for the purpose it was collected, removed, or for example, where the individual withdraws their consent or there's no legitimate interest in the continued processing of the data, or indeed if there's no continuing lawful basis for the processing. In all those circumstances, this right can potentially arise. Where the published data has been shared with other third parties, then they should be equally informed under this right of the erasure. There are recitals to this right in the regulation that make clear that in an online context, this means that a controller who has published the personal data should be required to take all reasonable steps, including technical measures, to tell the data controllers who are also processing the data of the subject's request for erasure, and also to erase any links to or copies of that data. As mentioned, this expanded right to erasure is one of a number of enhanced features of the revised data protection law, the European General Data Protection Regulation, that applies going forward to both controllers and processors of personal data when it comes into effect in May 2018. And it's going to include a range of new obligations, including those in connection with breach notification, with data portability rights, and requirements for enhanced data accountability and governance measures, among many other features. This upgraded law is reinforced by enhanced rights for individuals to claim damages where they've suffered material or immaterial damage as a result of an infringement of the obligations of the GDPR, which potentially is relevant in the context of what we've been talking about today. And as well as damages claims, non-compliant processing can also leave controllers and processors vulnerable to sanctions by the regulator. These range from regulator rights to information or rights to conduct audits of data controllers, but can also extend to applying administrative orders and ultimately imposing fines of potentially up to 4% of annual global turnover for certain breaches. Like the current data protection law, the regulation also includes a provision at Chapter 9 for member states to provide for exemptions in relation to specific processing activities. And this includes at Article 85 a provision requiring member states to give provide for exemptions for journalistic purposes. The recitals to the regulation also recognise the importance of journalistic purposes, and they point to the need to reconcile the protection of personal data with the right of freedom of expression and the right to receive and impart information, which is in accordance with Article 11 of the Convention of Fundamental Rights of the European Union. So it's clear that member states should be providing for exemptions for journalism. It's worth noting that the requirement rests on a necessity test, meaning that member states have to consider how any justifications to allow for processing, where it's for journalistic or freedom of expression purposes, that the freedom of expression will balance up against the data protection law. And it's also the case that the provision of exemptions or derogations don't extend to Chapter 8 of the regulation, so that means that the remedies, the liabilities and the sanctions may still be relevant in the field of journalistic processing. These aren't excluded. This means that the approach, because it's for member states to derogate from or introduce specific exemptions for journalism, it's likely that the approach that they take isn't going to be harmonised across Europe. So these exemptions may differ from country to country. But where these exemptions do differ, then it will be the law of the member state where the controller is subject, to which the controller is subject, that should apply. So moving on, I think we've got some polling questions to start with, and we've also had some questions in from a number of questions in from those that were listening in today. So whilst we're just looking at those questions, we'll just start by going through the polling questions that we have, and you should be seeing those on the screen now. So the first of these questions is, were you aware that data protection law could apply to media content, including newspaper articles? Yes or no? Do you think that data protection law ought to apply to media content? That's the second question, and again the answer is yes or no. And then the third question, going back to what we actually mentioned at the very beginning on Brexit, with the vote to leave the EU, will your approach to data protection change in relation to preparing for compliance with the General Data Protection Regulation? Yes, it's going to change. No, or you're not sure, you're waiting to see the outcome of the negotiations. So whilst we're just churning your responses to those three questions, Tim, I believe that we have some questions in from the listeners.
Yes, we've got three questions. One question is, do charities also have to prove serious financial loss as they've got no profits if they want to bring a defamation claim in England? And the answer there is, if it's a not-for-profit company, they do not have to prove serious financial loss, but they still have to prove serious harm to their reputation has been caused or is likely to be caused by the statement complained of. The next question is, can individuals use data received as part of a data subject access request to bring a defamation claim? Yes, and people often use subject access requests as a litigation tool to acquire information. And for example, if it turns out that there has been a defamatory statement that has been obtained as part of a subject access request, then they can bring a defamation claim as a result of that. And the second part of this question is, can this be used as an exemption? I think we've dealt with I'm not 100% sure what the question means, but I think we've dealt with the journalistic exemption earlier. If it's for the purposes of journalism, and if the processing is for the purposes of journalism with a view to publication, and the data controller reasonably believes the publication will be in the public interest, and they can refuse to give the information as a result of a subject access request. That's what happened in the Global Witness case. If the journalistic exemption doesn't apply, then they would have to give the information as a normal subject access request. And then another question we've had, can a media organisation lose the right to rely on the journalistic exemption if they share personal data with others within the media organisation who are not involved in the writing or publication of the article. They might lose the journalistic exemption if the processing is for a non-journalistic purpose, where it says to share personal data with others within the media organisation. So if, for example, they're sharing the personal data to add it to a marketing list, then they might lose the journalistic exemption. The processing, the exemption only applies to the extent the processing is only for purposes of the special purposes. But if it's still part of the purpose of journalism when they share the data with someone else, then the journalistic exemption should apply. I mean, it's a very fact-sensitive question, this one, so I hope my answer has done it justice, but it will all depend on the facts.
Thanks, Tim. We've got the poll results back, and just to remind you of the questions. So the first question was, were you aware that data protection law could apply to media content, including newspaper articles? A resounding 85% of you answered yes, you were aware that that was the case, and 15% answered no. In terms of the question, do you think that data protection law ought to apply to media content? Again, 76% of you answered yes, it should apply, and 24% answered no. Then with the question on, this is quite an interesting one, with the question on Brexit, with the vote to leave the EU, will your approach to data protection change in relation to preparing for compliance with the GDPR? I might take this in slightly different order. So 33% of the listeners said no, it wouldn't change, but 63% said that they weren't sure and that they were waiting to see what would happen in terms of the outcome of Brexit negotiations. To say, my gut feel on this is that those negotiations are likely to take quite some time, and the regulation in any event is going to enter into force before we leave the EU. So certainly from the standpoint of having to comply with the law, or even if when we do leave the EU, having to comply with a standard that is of an equivalent standard to the GDPR, I'd certainly say that the GDPR would be the compliance baseline moving forward. And then 3% said that they would be changing their approach in relation to preparing for compliance with the GDPR. So I hope those results are of interest to you. I think we have had one or two other questions. I'm not sure whether...
Yeah, we've got two more questions. Are there practical advantages to using data protection law, as well as not having to show the information is private or defamatory? Well, I think it really depends on whether there's a public interest. If there's no relevant public interest, then data protection law could practically be easier because there's a statutory regime which is sort of set in stone. Privacy law is generally common law, and there are the rights under Section 7, the subject access request right, Section 10, the right to stop someone processing, and Section 14, the right to Arrisia. So yeah, in practice it can be helpful, but on the other hand, you do get very similar results to traditional media law. So, you know, there's a practical advantage in being able to point to certain bits of a statute, but in the end, it may not make a huge difference in most cases. And then there's a second part of the question: are damages likely to be lower in data protection claims? Well, here I would say there's probably no practical difference because the judges who decide media claims are probably going to use the same guidelines and thought processes as they would use for damages in a privacy claim or a data protection claim, and in many cases data protection is added to a privacy claim, and so in the end it shouldn't make a lot of difference.
Thanks, Tim. Well, I think at that point we've reached the end of our allotted time. With that, I would like to say thank you for joining us today. We're now going to be taking a short break over August, which I hope you will be too, for some summer sunshine, and we will be back again with our webinar program in September, and details of our next webinar will be coming out to you ahead of that event. And so with that, I wish you a happy holiday, and I look forward to joining us again in September. Thank you.